right, thank you for staying with Citizen TV. This is Daybreak. My name is Trevor Mbija. We are speaking about arbitration in Kenya. If you're just joining us, let me introduce my guest one more time, starting from my father's right. Dr. Chikwedu Madumere is a CIAB Africa trustee. Thank you for making time. CIAB stands for Chartered Institute of Arbitrators. Asante sana. Jackie Oyuyo is a chairperson, Nairobi Center for International Arbitration, NCIA. Jacqueline Waihenya is a chairperson, CIAB Kenya. Thank you for making time. And Professor Kenneth Wayne Mutuma, Chartered Arbitrator. Thank you for making time. Let's see the questions that you're raising at Trevor Mbija at Citizen TV Kenya using the hashtag Daybreak. Questions on arbitration in Kenya. What is the difference between arbitration and mediation? How does ADR work? Is it expensive? Is it not? Bob Otieno Wino says, can an arbitrator influence someone's sentence in a court of law if dispute between warring parties doesn't come to a conclusion? In fact, we can answer these questions as we go in real time. So, Bobo Wino, and then there's J.M. Bobo Wino. Let's stay with Bobo Wino for now. He says, let's go back to Bobo Wino and stay with that question for a bit, then it's answered first. Can an arbitrator influence someone's sentence in a court of law if dispute between warring partners doesn't come to a conclusion? Any of you can take this. Prof. Yeah.
Well, I think the first point to clarify is that arbitration does not actually function in the realm of criminal law. So arbitration is essentially for commercial, disputes, investment disputes. But if we're talking about mediation, there is what they call restorative justice, which is now coming into mediation. So a mediator, or what they call a plea bargain, I don't know how it operates in Kenya, but in Nigeria and in some other countries of the world, you have a plea bargain and you have restorative justice, which is the infiltration of mediation into criminal law. And in that context, why not? You could activate the mediation option in settling this dispute.
Okay. Jacqueline?
Okay. Like Dr. Chikwedu said, the two, arbitration and criminal law, don't tend to work hand in hand. Like I said, when we have an alternative dispute resolution process, it is really customized or bespoke. So it would be very difficult to see an influence in the criminal court system unless, of course, a crime has been committed within the course of the arbitration, in which case then, in probably very rare occasions, then you would find that that would be invoked. Okay. So I think for now, the best answer would be that arbitration is more inclined to the commercial disputes rather than criminal.
Right. Could I just add on that? Prof. And I think it's important to add this. So there's a relationship, a hierarchical relationship between arbitration and the court systems. And I think that's important to add. We don't want judges probably listening to this thinking that we're putting out the idea that arbitration can influence the court system. Actually, we come at a lower spectrum. So the parties sort of agree. And what we tend to find out, even in that commercial context, that there are provisions for the parties, one of the parties, to challenge what may actually come out from arbitration. So the court system sort of sits above the arbitral proceedings. That's a very important perspective to come out. Thank you.
Okay. So, yes.
And possibly, as much as it sits above, there are instances in which we sort of walk hand in hand with the court system. So the court can provide assistance, if you will, to an arbitral process, but it is limited. In most of the arbitration acts, you'll see, as my brother mentioned, the New York Convention provisions are inherent. The spirit of the conventions is present in the acts. So our act, for example, at Section 10 will say the courts can only intervene in the manner that is set out in the act. So we can ask the court to assist, for example, with taking evidence. We can ask the court to assist in terms of enforcement. So it's a hand-in-hand process, but as Prof has said, we don't do what the courts do. We don't try to take on the role of the courts. Unless we need the court's intervention, then we will seek it in a very limited manner. Okay.
There's one more question. Let's bring it up and see what your question was. I believe it was Baraza or Godi who asked that question. Let's bring that up and see. J.M. Musoma says, kindly ask the panelist, what are the qualifications of a chartered arbitrator in Kenya? does it require a person to come from a legal background, or is there a specific course one can take, and from which institution?
Okay, well,
yes.
I think that comes to CIAB.
And then CIAB.
Okay, so at CIAB Kenya, we administer training.
Yep.
And we administer training to any person with a first profession. And what I can say is that actually our membership comprises not only lawyers, but engineers, architects, we have accountants, and even medical, people from the medical field. So even you, Trevor, could come and join us and get certified. The process is actually standardized around the world, and we train with the same approach in Nigeria, in Kenya, even in Kigali, or anywhere in Europe or even America. But what the process entails is an entry course, that is the entry level, where you're introduced to what arbitration is, where you're introduced to the distinction between arbitration and the other mechanisms, mediation. We also have conciliation, construction adjudication. And then once you have had the opportunity to do entry course, then you are eligible to do 3 modular courses in a graduated scale, starting from module 1, and then 2 and 3. And in each module, you acquire more specialized knowledge in arbitration, if you like. And with the final stage, then you acquire the fellow status. And the fellow status is a higher certification level. When you talk about the chartered arbitrator, I think we're all chartered arbitrators here. It is a peer review mechanism. So your peers, those in the field and have seen the kind of work that you have done, they will take you through a process where they can allow you to also acquire the peer review status of chartered arbitrator. So chartered arbitrator is the highest. We call it the platinum qualification in the world because it's recognized everywhere in the 160 countries that I had earlier mentioned. Yes.
And Dr. Madumere, let me bring you back on this. What do you see as some of the challenges that still need to be overcome when it comes to arbitration? Because I know that there's the Nairobi Arbitration Week that has just come to an end. Also, as you give us your reflections on some of the lessons you picked from them, some of the challenges as well.
Okay, so thank you very much. Let me just, I couldn't miss, reinforcing the answer, given by Madam Chair. And because the question the gentleman asks speaks, very deeply into who we are and what we do as a chartered institute. I must mention that in 1915, when this institute was established, there was no barrister. 5 professionals came together to establish the institute. There was no barrister amongst them. So arbitration is not for lawyers alone. In fact, the best of arbitrators are non-lawyers. So you could be an engineer, and that aspect, Kenyan branch has done so very well. And everywhere I go, I make reference to them in terms of diversity. You could see engineers, you could see architects, you could see, so everybody's welcome. And as long as you go through what they call the elementary principles of contract, elementary principles of evidence, I mean, you will just be fine. Now, with regards to the question that you asked in terms of challenges, I think basically what we need to keep doing, which is what Kenya is doing, and which is what other branches are also doing across Africa, is to deepen our trainings and deepen the reach of the practice within the context of every country. What we are doing just now, sensitizing and creating awareness, to what we do, sensitizing awareness to the advantages that the process offers, to people, and all of that, and then ensuring that we reinforce our young member group. Because there has to be a next generation, seeking to take over. Now, internationally, Africa, we keep saying it, even in the conference that we just had, that a lot of work is generated from Africa, and a lot of work is not done by Africans, because, like Madam Chair had mentioned earlier on, party autonomy. Parties will pick and choose whom they want to appoint as arbitrators. But as we keep training, we keep developing expertise among ourselves, gradually African voice is being heard. African involvement, is being enhanced. So what I think we should keep doing, increasing training, increasing awareness, and then opening up, the process to people to come in and participate. Because before now, you could see that in countries, I don't want to mention any country, the practice was like a closed circuit practice, but you could see that across Africa, the involvement of people, is a lot more widened. A lot of people are coming in, people are bringing their expertise on the table. I'm a beneficiary of that. I'm a beneficiary of inclusion. I'm a beneficiary of, equality. So that is why I preach that gospel everywhere I go.
Okay.
Yeah.
Prof, in the Arbitration Week, what are some of the lessons you picked from there?
There are quite a number, but I'll just piggyback on what he has said. I think an important facet for addressing the challenges in arbitration is what you do with the court systems. So the courts, as you heard from Jackie, play a very complementary and synergetic role with arbitration. So they need to understand what this process is and how to support it. The last thing you want is when the parties agree on something and then they come out with an outcome, but then the courts don't understand fully what that process looks like, and then you get back again into the main formal judicial system with all the challenges that it may have. So in this part, we've had a very, very rich relationship with the courts. Primarily, I think, because the Chief Justice is a patron of SIAB, Kenya. So she's done a lot of work to grow capacity in that level. And you'll realize that one of the things that influences the destination of investment has everything to do with how rich dispute resolution processes have developed in a particular country. So, and they tend to look at not just the capacity issue, which Dr. Madumere spoke about, but also how the courts from the same context have been capacitated. So moving then to the conference. So the conference dealt with many contemporary issues. And I'll let Jackie actually weigh in as the chair of NCIA. So we were looking at the environment, which is a hot topic, and the implications of disputes in that terrain, and also arbitral practice when it comes to language like sustainability, sustainable development, and so forth. So there are various, let me call them nuances, areas of gray, where, for example, we are seeing countries now grappling with the extent that there is an encroachment of policy issues, specifically coming from the environment, or what they often call ESG, the environment, social governance, on these private dispute processes, and how arbitrators then should position themselves. I think the other area that we discussed very much during the Nairobi Arbitration Week was the issue of technology and what that is doing. So we are not spared. Like in every other industry, the media, to give a useful example, the digital revolution is having a massive impact, both as a dispute platform itself and also on how disputes themselves are resolved. So as an infrastructural issue, and we discussed that, in really enormous lengths. And the richness of the conference, of course, was to have the international board practitioners body present. I think we had people from all over the world, Africa, Asia, Europe, and to also have the user, because sometimes you have these discussions in closed doors, and to avoid that echo chamber effect where we're just speaking amongst ourselves, we also had quite a number of people who use this dispute resolution as a product. So I think it was an enormous success from that point of view. I think probably NCIA chair can speak in greater length on that issue.
Yeah, I'll give you the broader spectrum of this because you're running this, but let me bring in Jacqueline first on this. And the main concern that most people have when it comes to proceedings, either legal or arbitration, whichever direction, has always been the cost. Do you consider that as part of the challenges, or is it even cheaper to do it, first of all?
Okay. Well, this has been coming up quite a lot, and I think it's one of the topical issues, and we also discussed it during the conference as well. Cost is relative.
Depends on who's speaking.
Yes. And the term I usually prefer to use is cost-effective.
Yeah.
And it ties in with my views on appropriate dispute resolution. If you choose the wrong mechanism, definitely it's going to be costly because you spend a lot of time and you'll not really achieve the end that you wanted. That said, some of the mechanisms tend to be perceived as cheaper. That is not necessarily true, but when we engage with the consuming public, we tend to get the feedback that mediation is cheap. Mediation is not cheap as well, but when you look at the context of the level or the amount of the disputes that we take into account, then it feels a little fairer on the pocket. And also, sometimes the types of dispute will determine or dictate what the cost will be. At CIAB, what we've done, we have come up with what we refer to as the Arbitration Rules of 2020, which, because arbitration is perceived to be the most costly of the private, the alternative dispute resolution mechanisms. And we, in the rules, we've put a cap of the cost and can be applicable to smaller value claims, so that when, if you subscribe to the rules, then you're able to negotiate with the arbitrator and say that the rules, CIAB Arbitration Rules 2020, provide for a cap. And the only limitation is that we categorize those claims as those that are valued at 10 million and below. Those that are above, then we have a scale that we put in place. And the different resolver, because you're choosing somebody, when you choose the arbitrator, you know the qualifications that are appropriate. And when you bring them to the table, you say, and this is what the scale provides, there's a scale value for the associate, for the member, and for the fellow and the chartered arbitrator as well. And that is what we try to enforce, to see that whatever the consuming public, whatever the parties have agreed to, the person they have chosen, they get good value for money. So I'd prefer to have a conversation in terms of value as opposed to limiting it to shillings and cents. Because you could also, and sometimes this has happened, sometimes, and I'll say this in the context also of legal proceedings as well, if you economize on the representation that you that you're looking at, and I think we had a panel who spoke about this, saving pennies and it costing millions at the end of the day, or even billions, depending on the exposure. So it is important, and as we're having this conversation, it is important that we also sensitize the public that when you're walking into the legal arena, it's not, and I think the lawyers tend to experience this, wakili, a moment.
It's
so,
pro bono consultation.
If you have pro bono consultation, then you will probably end up having a pro bono exposure if you're not careful. So if you can afford, especially, it is important to make that investment so that you don't pay extra at the end of the day and then really feel the pinch because of maybe a small technical matter that could have been resolved by a competent person who has specific or expertise in that area. They can end up saving you a lot of money in the long run. So the cost discussion, it has two arguments, it has two faces, but I think the most important thing on what I would like to communicate to the viewers is that let it be a consideration that you take seriously so that we are cost efficient in dispute resolution, whether it is in litigation or whether it is alternative dispute resolution in ADR.
All right. Jackie, what lessons are you picking from the Arbitration Week?
Maybe let me take it a step back and say why we have a Nairobi Arbitration Week. So the Nairobi Center for International Arbitration, this is the second edition of the week. The first one was in September of 2023. And the idea really is to create a platform for conversations around dispute resolution. So it's not so much a conference in the traditional sense. It is really just enabling specific conversations between, as my colleagues have said, dispute resolvers, users who may come from a broad spectrum. They may be business people, they may be experts in specific areas of competence. They may be even students to some extent. So the idea really is to have everybody converge in Nairobi for this conversation. Why? In order to position Nairobi as a hub for dispute resolution. And this happens across the globe. So you will have Paris Arbitration Week, you will have New York Arbitration Week. And this year we decided to partner, well, our co-hosts is the Chartered Institute of Arbitrators, so that they then have their conference within Nairobi Arbitration Week as part of the conversation. What are some of the lessons, Trevor? For me, I love tech. So the tech day in particular was mind-blowing for me. So you have expertise in tech coming to talk about how tech is impacting even how parties enter into contracts, for example. What is the nature of those contracts? What are they looking like? When we talk about AI, how is it impacting even arbitral practice? Are we adopting AI in our practice as arbitrators, for example? So sector-specific conversations. We had the telcos also weighing in on 2 or 3 of the panels. We had the energy sector. So broad conversations of the business community with the dispute resolution community. So all with the intention of then promoting Nairobi as a hub for dispute resolution. And even as we do that, important to understand that, at least from an NCIA perspective, we look at the full spectrum. So from giving the awareness of what the dispute resolution mechanisms are, training in the dispute resolution mechanisms, and then if you have a dispute, helping you appoint from our panel of arbitrators and mediators, both domestic and international, administering the dispute, which means we are the secretariat for the dispute, providing hearing facilities, including virtual hearing facilities. So from NCI perspective, we look at the full spectrum then of the dispute resolution process, right from your sensitization to your actual execution, and then your continued awareness through weeks such as the Nairobi Arbitration Week. And before I close that particular statement, let me say, because I feel very passionate about it, you do not have to be a lawyer to be an arbitrator. I have put this challenge to the media several times, and I will put it to you, Trevor. Take it back to the Kenya Union of Journalists. Let's have more journalists, for example, coming into the practice. The wider the spectrum of professionals is, the more enriched the processes are, whether it's mediation, whether it's arbitration, or any other process. So, Trevor, I will be waiting for you with a form so you can sign up to train as well.
I love that challenge, but my question then is, how do you deal with the bias or perception of bias? Because you see, the thing is, I may have been seen with Dr. Madumere here, and then somebody has a dispute with him, but then if I'm chosen as the arbitrator, they feel, Dr. Madumere and Trevor have shared a panel before. These people know each other more than I know. So how do you deal with that perception of bias?
I will answer that question briefly, because if I go into it, it's a whole module in our training. There are 2 things we're handling when we talk about bias. Your independence as a neutral and your impartiality. Now, independence is a question of fact. You were seen with Trevor on a panel. Fact. Impartiality, the fact that you were seen with Trevor, does it influence you towards or away from Trevor in one way or another? When we're dealing with this, I always say, and especially when I'm training, if you have any doubts, disclose to the parties. Let the parties then have the agency to decide. The fact that you were seen together on a panel means that you are biased and therefore you're not the suitable person. So if I go into the details, we have prescription. The International Bar Association has guidelines specifically on different scenarios, and they're getting more and more prescriptive because more and more situations are arising. Getting more prescriptive around, for example, if a law firm has in the past advised one party, is it the fact that a partner of that law firm is the proposed arbitrator, is that enough to then suggest bias and lack of impartiality? So, like I said, we can talk about it a lot, but my advice to anyone who is coming into this field is always, if you have any doubts, disclose to the parties. If it's so obvious, you must disclose. And then you give the parties the capacity then to decide whether you are in fact biased or not.
And Dr. Madumere, I'd like to hear your reflections on this issue of bias, because I bring this up because it's more of a perception thing. Because even in the courts, we've seen judges recuse themselves, say that I know so-and-so, so I'm not going to do this. But when it comes to an agreement where there's a dispute and you pick someone, then the issue of bias comes up a bit more prominently.
Yeah.
What is the best way of addressing this so that the public understands that it is okay, you may have it, but this thing can still be done professionally, arbitration can still be done?
Yeah. So thank you very much. But could I just give my thoughts on the question of cost that you raised?
Yes.
Now, in arbitration, there's a principle we call cost follows the event. What that means is that the winning party gets all his costs back. And that is one of the attractions of arbitration. If you were to litigate in court and you hired a senior counsel based in Nairobi and you paid the senior counsel 1 million shillings and you won 5 million, how much have you won? 4 million. But if you were to litigate in arbitration and you hired a senior counsel and you paid the senior counsel 1 million shillings, you will get the 5 million back and you get the 1 million shillings that you paid back. Because, and that is attractive to business people, because the whole essence of it is to put the winning party back to where he should have been, but for the dispute. You know what they say in the scripture about a man made whole who was restored to where he should have been. So what we seek to do in arbitration is to restore the winning party back to where he should have been, but for the dispute. So that's an attraction. And in addition to what Madam Chair talked about, the real cost. Now, to the question you asked with regards to bias, that is a very fundamental question. And Madam Jackie had given an excellent answer. But just to reinforce what she said, you will want to know that in arbitration, the process runs on trust. Trust of the parties in the integrity of the process, trust of the parties in the integrity of the arbitrator. So, and that is what, that's trust, now puts a burden on the arbitrator to ensure that that trust is not eroded in any way. And that is why when you look at the laws of arbitration, in certain sections, I don't have offhand the section in the Kenyan law, but I know that under the model law, Article 12 says, whenever a person is approached for appointment, that person has an obligation to disclose circumstances likely to affect or likely to raise doubts regarding independence and impartiality. But the model law, as in most arbitration laws, do not specify those circumstances. And that is why the international, what they call it, soft law in public international law, which is the IPA guidelines on conflict of interest in international arbitration, now comes in. It gives you a broad spectrum of circumstances likely to give rise to independence and impartiality. Now, let me break it down a lot more. Yeah. When you talk about independence, you are talking about the relationship of the arbitrator with the parties. When you talk about impartiality, you're talking about the relationship of the arbitrator with the dispute of the parties. How am I related to that dispute? Do I have any connection with the dispute? The IBA guidelines gives you a breakdown of those circumstances. And that is why in this institution, Chartered Institute of Arbitrators, as in Nairobi Center for International Commercial Arbitration, we emphasize ethics. Ethics is very, very important. The arbitrator, like Caesar's wife, must be above board. Above board in disclosing circumstances likely to, to impair the trust of the parties on the process. And because once that trust is eroded, it affects the outcome of that process, which is the final award. No arbitrator wants to have his award set aside in court. Yeah. Because it speaks to your expertise. Parties had paid you money, they had invested their time and resources. What you want to do as an arbitrator is to render an award that is valid and enforceable. So, yes, there could be one or two instances, where issues of ethics had arisen, but in a broad, consideration of, perhaps over 100, you could see that in about 100 arbitrations, over 99 had passed that test of ethics. Yeah. And we continue to emphasize that requirement. I'm sure within the branch, you have such, ethical requirements, because at the headquarters, we have our disciplinary committee. Anybody that goes off track, is dealt with. So because the system has to run, and it has to run in a way that does not erode the trust of the parties. Yeah, and Prof. Dr. Madumere brings in a very interesting perspective and very fundamental in terms of the arbiter needs to be, like Caesar's wife, above reproach. But are there any circumstances where a settlement has been reached
and then there's an appeal. Is there even a system of appeal? And what does that then say about the arbitrator, or is it the aggrieved person? Because always when you lose a case, there's that feeling that this should have gone my way. So is that a reflection of the arbitrator or a sour loser?
Okay. So first, I think on the question of bias, we need to underscore this is not a small pool of people. I just wanted that to come out. It's really an international pool. So he sits as one of our members in terms of appointments. So if you're looking at maybe Jackie and I as a potentially conflicted and questions of impartiality arise, the system allows you to get people from as far as other parts of the continent all the way to other jurisdictions completely.
Who are not involved in local politics.
Who are not involved in local... and that is why we have really been pushing for more and more industries to come on board. Not necessarily because you'll arbitrate a matter within your industry, but you might be very useful in the construction industry, in the energy sector, and so forth. Disclaimer and disclosure, we do have someone from the media. I won't mention them because for obvious reasons, and I hope they will bring you on board. So they are in our training. Now, on the question that you asked, there is a relationship actually between the outcome of an arbitration process and the courts. So if you look at what we call Section 35 of our Act, it provides for grounds when what we call an award, the decision that comes out of the tribunal, can be set aside, including some of the aspects that he mentioned, how the procedural aspects, questions about whether you dealt with the issues at hand, you exhausted them, and more importantly, issues like public policy. So the courts can step in, but they step in not on questions of merit, but procedural aspects, what we often refer to as procedural justice, whether due process has been followed and so forth, and these are the aspects I had mentioned. When they do, now let me give my personal perspective. We don't have an advertising platform. So the best thing that you could ever actually do to me is to get my decision affirmed by the courts. Because that now, we use the Kenyan local franco, it's sambazzled everywhere. And everybody knows that this decision was sound. You can actually get very good services from this specific arbitrator. But it also acts as a review system for the bad apples, because it will get up there. And he talked a lot about the bad apples. And in the same way, because the process is very confidential when you are at the arbitration stage, when this decision gets out and it's maybe the subject of reprimand, rebuke by the courts, it does something very positive for us as an industry, because it tells the user that, don't expect this out of this process. And the arbitrator in this specific instance went offline. And I think, Jackie, maybe you could even speak about many other instances where the relationship between the courts facilitates, supports, and actually reinforces the ethos of the industry.
Okay, maybe I can jump.
Prof has seeded his ground.
Okay, when we have this discussion, I like to think about the question being about the arbitrator being independent and impartial. And what Professor has said is really the courts coming in to ensure that the arbitrator is independent and impartial right from the word go. And when we talk about the partnership with the court, what the law provides and what the institute provides is that the court shall not interfere unless as otherwise provided in the Act. And our Act is the Arbitration Act. So when we start and I appoint an arbitrator, the first question the parties ask themselves, okay, are we okay with this person? And then if they have a question, they will challenge it. And the place to do the challenge is actually in court. And, you know, when I appoint, then I put everybody in communication with each other. At that point, the arbitrator is required to make a disclosure and to say, I know so-and-so. We went to school with them, or we have appeared in a panel with them, or we have served in a board of directors together. Yeah. Because as you will realize, very many people tend to interact quite a lot, particularly when either in the public sector or in the private sector. I know the trajectory of somebody's professional career can take them in different places. So when that disclosure is made, the parties have the first opportunity to say yes or no. If they say yes, then they move into the next stage, which is now let us get on with the hearing. And when the hearing then commences, there are some things that the arbitrator could not have known. For instance, there could be a witness who turns up in the process, and then they realize, oh my goodness, I know this witness. So at that point, again, they have a duty to disclose that when I started, everything was okay. There's this new development that has exposed. So if it has changed things. So at least now, in the second stage, you now have an opportunity also to tell the parties, okay, let's sit, let's, come, let us reason together. It's the same way as in the Bible. If they say yes, then we proceed to make the final award. Okay. The curious thing, maybe not so curious, is that when the final award is then delivered, usually the losing party is the one who says, oh, by the way, there was bias. This argument usually comes up at that point in time. But the good thing is, when the disclosure was made, and the party said no, and the arbitrator then said, I will continue, they have a recourse to take it to court. That is now, that's at that point. So the court also comes in that way. But if no application was made, we continue with the process. It's supposed to be flexible, quick, fast, cost-effective. Let us get on with it. Let us get the final award. When the award is delivered, then the court comes in to recognize the award first and enforce the award. And the court is also equipped to, make a determination on whether the issues that have been raised actually do point to bias existing. All right. All right. And Jackie, I know you're the one who kick-started this conversation, so it's come full circle again. But there's a lot of questions coming through. Let me see if we can squeeze in 2 more, and then I'll come to Jackie and Daktari for closing remarks, because we really press for time. Let's just see if we can squeeze in those questions really fast. Sir Nixon says, where do you report biased and corrupt arbitrators? Okay, hold on. Let's take the other question, then you answer both. Arnold, what's the role of arbitration regarding an already convicted person? For example, can it overturn a fine, for instance, already imposed on an offender by a court? Jackie, where do you report someone who's considered corrupt?
First port of call would be to raise it with the arbitrator. Okay. And if, of course, there's no stepping aside, if you will, by that arbitrator, there are mechanisms in any statute to then enable the party apply to, in this case, in Kenya, the High Court, for the removal of that arbitrator. In terms of reporting and then requiring some discipline around the conduct of that arbitrator, the current mechanisms are deficient, I will admit. So what NCI initiated and then was subsequently taken to a task force appointed by the Attorney General, and my sister Jackie was, I think, vice chair of that steering committee. We have then drafted a national policy on alternative dispute resolution. And one of the things that it then envisions is that institutions will have to have disciplinary processes for their members. So whether it's an arbitrator, a mediator, whoever goes rogue, then there will be some reporting mechanism, and there will be a disciplinary procedure for that. Having said that, as Jacqueline had earlier said, most, if not all, arbitrators or mediators have a primary profession. So let's not also forget that I can also be reported. For example, I'm a lawyer, to the LSK for any misconduct. So that process already exists. and whether it's an engineer, an architect, or anybody else, a medic. And by the way, even at Nairobi Arbitration Week, we have a neurosurgeon who is participating. So very important then to understand that the primary profession has disciplinary mechanisms, and in the national policy, we are proposing that there be disciplinary measures by the institutions of their members to ensure that rogue behavior is then punished.
Okay.
If, of course, it's of a criminal nature, for example, you took a bribe, nothing precludes a party from taking then the normal channels for prosecuting for bribery or anything else.
And there was another question about, can arbitration overturn an already convicted person?
So this is similar to the question my brother had answered earlier. We don't walk in criminal corridors, so to speak, as arbitrators or mediators.
Stay away from it, yes.
So that would still be under the normal criminal justice system.
Okay.
Yeah.
All right. And Dr. Madumere, I'll let you close this conversation for us in terms of your reflections and looking forward. What do you think needs to change to enhance the arbitration or alternative dispute resolution across from a continental perspective?
Okay, Doctor had actually, Prof had actually, hinted, answers to that question earlier on. If you look at the landscape in Kenya and indeed across Africa, our judiciary, is becoming a lot more supportive of the process. For instance, in Kenya, last September, 6 of the justices of the Supreme Court were inducted as fellows of the institute, and the Chief Justice is a patron of the institute here, of the branch here in Kenya. Also in Nigeria, a lot of our justices are members of the institute at different levels, member level, fellowship level, and all of that. So, as he said earlier, even though the mechanism is a private mechanism, at different critical points of the mechanism, it requires the support of the court to run effectively and efficiently. And that support is increasingly being enhanced as a result of the trainings and understanding of the court and the role of the court in the process. That is number one. Number two, in terms of increasing the penetration of arbitration within Africa, our national legislation across Africa, like in Nigeria, we have a new law of 2023, which reflects the current version of the model law. I'm aware also from discussions at the conference that even Kenya is also thinking of amending the law of arbitration to also reflect best practices. In the UK, 2025, just about 3 weeks ago, the UK passed a new law on arbitration. Israel passed a new one in February of last year. So countries are increasingly improving their legislation. Number three, infrastructure. People who want to come to Nairobi to arbitrate, knowing that they have the basic infrastructure in place. The same thing in Zambia, the same thing in Lagos, the same thing in Kigali. So, and institutions like the NCIA, are springing up across Africa, also providing services, administrative services, support services, to arbitration. And most importantly, training. A lot of Africans are being trained, and the expertise is growing. So the landscape is looking very attractive.
Okay.
Thank you.
Thank you so much. Thank you so much for making time for us this morning, ladies and gentlemen. Dr. Chikwedu Madumere, Siab Africa.
Unless you pronounce my name correctly, I won't leave this much.
Let's do this. Teach me. It's Dr. Chikwedu Madumere.
Chikwedu Madumere.
Chikwedu Madumere.
Yes, sir.
All right. Thank you so much for making time. Siab Africa trustee, Jackie Oyuyo, chairperson, Nairobi Center for International Arbitration, NCIA, Jacqueline Waihenya, chairperson, Siab Kenya, and Professor Kenneth Wayne Mutuma, chartered arbitrator. Thank you all.
Thank you very much.
This morning.
Thank you for having
All right, that's why we leave it for now. We're taking a quick break on Daybreak. We're back with much more in just a bit.